Dear Chairperson, dear Ms. Medenica, ladies and gentlemen, I'm very pleased to have an opportunity to attend this very important symposium which discusses this very inspiring topic. Having in mind that the agenda has changed, I'll try to reduce my presentation and I'll speak about international law and human rights with the focus on the protection of individual rights or the rights of individuals and groups in Montenegro from the point of view of the Ombudsman institution. Historically looking, human rights is something that is derived from the new century and modern time. The first document that guaranteed these rights were drafted in England in the 13th and 17th century. They were created as a form of limiting power and state regarding the private sphere of individuals. Human rights refer to basic rights of human beings, the rights that do not have to be acquired, but have to be given based on their own existence and independently of the state they live in, and regardless of the fact whether the person has citizenship or is a displaced person or a refugee. For a long time, international we thought that these rights belong to certain groups, but now later it was realized that they belong to groups as well. Sometimes it is difficult to distinguish between human rights of individuals and human rights of groups, having in mind that some rights are personal, for example, the right to life. Some rights belong to groups exclusively, for example, the right to self-determination, and there are rights and freedoms referring to individuals but are expressed through a collective group. For example, the right of minorities, interdependence of countries, and awareness that human rights cannot exist if they're not respected, at least in a minimum level, in all states, have brought to different mechanisms of protection of human rights, especially within the EU system. When this endeavor is a conviction that for all society there is one core of basic human rights and freedoms, the so-called minimal standards within human rights that all states should adhere to. Thus, these rights have become a constituent part of international law. This process started by adoption of the UN Charter, the Universal Declaration and other international documents that we heard quite a lot about yesterday. I'm not going to speak about it. I will just mention the most important regional instrument for the protection of human rights, individual European Convention of Human Rights and Fundamental Freedoms, and protocols of this convention. Adoption of these documents and a series of other conventions meant that the problem of the issue of internationalization of human rights grew from the stage of formal guaranteeing of human rights into the stage of formal implementation of these documents. After mass violations of human rights, especially in the process of disintegration of former Yugoslavia, when the international community erected physically and legally the process of strengthening human rights and the guarantees for these rights has made a process in the area of Western Balkans that are now in the process of integration, including Montenegro. Montenegro proclaimed independence on the 3rd of July 2006 and adopted a declaration which accepts the principles established by the documents of the UN, the Council of Europe, OSCE, and other international organizations. in the new constitution of Montenegro, which belongs to shorter constitutions and which was drafted along the model of the constitutions of modern democratic states, almost half of the constitutional norms refer to human rights and freedoms. From the proclamation of independence, since then, we have had an improvement in the implementation of the norms of human rights. Our legislative and legal practice is giving up the heritage of wrong ideas on the role of international law in the field of human rights. We are intensively abandoning the traditional defensive attitude regarding direct application of human rights in the country, and we are overcoming the shortcomings in the knowledge of human rights. Many occasions we heard yesterday that the new constitution of Montenegro contains a norm that defines that the confirmed and published international treaties and generally accepted principles of international law are constituent part of internal legal system and have supremacy over domestic legislation. In this way, the Constitution of Montenegro gives supremacy to international law and defines the possibility of its direct implementation. In this way, it resolves all legislative and legal ambiguities. The Constitution is clear in terms of implementation of international law. Now, it's up to the institutions of the system to apply this clear constitutional norm. We don't have problems with ambiguities and norms, whether accepted norms can be directly implemented or whether we need to incorporate them into the domestic legal system. However, we still have the practice that after ratification of some legal documents, their incorporation is still done in the domestic legislation. Sometimes, of course, it is necessary because some international documents just give instructive norms. In the accession to the EU, the rules of mnemotechnics recommend that as many international norms are incorporated into the domestic legislation. Adoption and ratification of international documents dealing with referring to human rights and freedoms represents just the first step in the protection of these rights, because these documents are worthless unless we provide their effective implementation. And therefore, it is important that we have not only mechanisms for the protection of human rights and freedoms defined by international documents, but also that we have national mechanisms out of international documents on human rights. About these documents we have talked a lot about, but the most effective mechanism for ensuring human rights and fundamental freedoms is the European Court of Human Rights, established on the basis of the European Convention on Human Rights. Compared to the European Convention of Human Rights, International Covenant on Civil and Political Rights defines a Committee for Human Rights, and some citizens from member states can refer to by means of complaints. And there is also the Covenant, International Covenant of Economic, Social and Cultural Rights, and its optional protocol defines the Committee for Economic, Social and Cultural Rights, defines the possibility for citizens to complain to this committee for the purpose of protection of their rights. Norms of these covenants and both committees are not binding compared to the decisions of the court in Strasbourg, and there are no specific sanctions if their decisions are not taken into account. Montenegro is a signatory state of international instruments, and its citizens can complain to the mentioned international bodies after exhausting all legal remedies in the country. According to my findings, our citizens mostly complain to the court in Strasbourg. I don't have the data about complaints to the other mechanisms defined by international covenants. All international case law, judicial and quasi-judicial bodies that are work on the complaints apply the principle that the person first has to exhaust all legal remedies in the country. It maintains the general principle of international law based on the conviction that the state must be given every possibility to remove violation of its international obligations through its international system before it is reviewed by international body. In addition to these international mechanisms for the protection of the rights of individuals, our Montenegro national legislation defines different mechanisms for the protection of human rights and freedoms, and one of the most important ones, the most significant ones, is the judicial system, or getting protection of human rights within a court proceedings. In addition, we have the protection by the Constitutional Court based on the constitutional complaint. According to the report of the agent of Montenegro in Strasbourg, by the end of 2013, the European Court for Human Rights in Strasbourg was working on 1,062 applications of citizens and legal persons from Montenegro that asked protection because of the violation of the rights from the Convention. Out of these 1,062 applications, 26 are in the stage of main hearing, and out of them 18 refer to the violation of Article 6 of the Convention, violation of the right to a fair trial. Constitutional complaint is a legal remedy that in practice should represent the national legal mechanism of prevention of international mechanisms against Montenegro that physical and legal persons submit before the Court of Human Rights. However, the European Court of Human Rights, deciding in cases against Montenegro, in its practice so far, has concluded so far that the constitutional complaint in Montenegro still does not represent an effective legal remedy within its legal system. Since 2003, in the legal system of Montenegro, we have had another specific mechanism for the protection of human rights and freedoms. That's the Ombudsman of Human Rights of Montenegro. In accordance with the Constitution, the Ombudsman is an independent institution that undertakes measures aimed at protection of human rights and freedoms and performs its function based on the Constitution, law, and confirmed international treaties adhering to the principles of justice and fairness. We don't have the authority to change the acts of state bodies. It is not a competition or a replacement for any existing institution, or it cannot limit the standard competence of other bodies. We don't assume any of their functions or interfere with the balance between executive and judicial power. We just help them to perform their duties and obligations in the field of human rights and freedoms in a better way. It is a mediator between citizens and public administration. Ombudsman also helps both parties, to citizens to exercise their rights and freedoms, and the public administration to be more efficient, to be more cultivated, to have a lawful work or operation. So the task of the Ombudsman is not just to protect human rights and freedoms. The task is to strengthen constitutionality and legality, as well as justice and in specific life situations. So its role is twofold. On one hand, it protects the rights of citizens. On the other hand, it works in the interest of the society as a whole. The dominant role of Ombudsman is the protection of individual rights and proceeding in accordance with the applications of citizens. Since the topic of this symposium includes court protection. I will just speak for a couple of more minutes, and I will say something more about our role regarding court protection. Along the Swedish model of ombudsman, Ombudsman has limited competencies regarding courts. We can act in accordance with applications of citizens only if the violation of the right to a fair trial occurs, or if the court decisions are not executed. In the first year after the institution was formed, most applications referred to the work of courts. It was up to 70% of all the applications of citizens. In 2008, we had 41% of applications out of all number of applications that referred to the work of courts. And in 2013, last year, the share of these applications was only 13%. What was the consequence of this? Because we improved the accuracy of work of courts. With the increase of accuracy of work of courts, we have a reduced need of citizens to refer to ombudsman and ask for their right for a fair trial. If we add that most of these applications, or more than half of them were assessed as unacceptable because they did not refer to the right to fair trial, but to the content of the court's decisions. And since courts decide based on the law and constitution, in these cases we cannot do anything because we don't have the competence to interfere with the court decisions, with the judgments. So what I can say is that it is very encouraging and very positive that the accuracy of, in courts is increasing, that the backlog is reducing from one year to another, and we have almost reduced the backlog to zero, and I think we are increasing in such a way the court protection, we are increasing the guarantees for the protection of human rights in freedoms in the court proceedings. To what extent the Ombudsman helps citizens, and to what extent it is a filter so that the citizens don't refer to the court in Strasbourg, is the assessment that can be given only by the citizens. But I think we have made a significant progress because we dominantly protect human rights of citizens from a public administration. We supervise the public administration, or bad administration, if you want it. Thank you for your attention.